Thank you very much for being invited. I probably should add, as Dr. Tang did, that I'm not speaking on behalf of the medical school or other organizations I am affiliated with. I'm speaking as a bioethicist who is often being asked to examine the ethical aspects of particular healthcare programs, or ethical quality, if you wish. And because of that, I became interested in ethical issues concerning MAID. There are many, but today I will speak only about one of those issues, which is very relevant to the current discussion on Bill C7. And this is the lack of accountability and lack of transparency. These are characteristics which were promised on the paper, but failed to deliver. In order to prove my point, I have to go back again to the beginning of this, the history. In Canada, it is still indictable offense to counsel a person to die by suicide or aid a person to die by suicide. No person is entitled to consent to have death inflicted on them, and such consent does not affect the criminal responsibility of any person who inflicted death. These were the provisions which were inserted into criminal code when it was created in 1892, and they are still valid. Only thing is the change instituted in 2016, at which time, as already Dr. Tang explained, the Supreme Court determined that the absolute prohibition is in conflict with the Charter of Rights and Freedoms, and as a result, sketch certain conditions under which the prohibition need to be invalidated. The court was persuaded, and I will quote, that the risks of physician-assisted death can be identified and can be minimized through a carefully designed system that imposes strict limits that are scrupulously monitored and enforced. Well, based on instructions of the Supreme Court, the Parliament approved Bill C-14, which made it possible to provide medical assistance in dying in spite of the general prohibition of homicide, which I mentioned above. It was implemented with three basic conditions. One, that assisted dying will be provided by medical practitioner or nurse practitioner. Two, that the person will applying and receiving MAID will meet 5 eligibility criteria, and 3, that the MAID provider will follow 9 procedural safeguards. The law states, and I quote, robust safeguards reflecting the irrevocable nature of ending life are essential to prevent errors and abuse in the provision of medical assistance in dying, unquote. And then also declares that vulnerable persons must be protected from being induced in the moment of weakness to end their life. The law states also that MAID provider who knowingly fails to comply with the safeguards and may receive a jail sentence for up to 5 years. This 2016 law also states that the Minister of Health must make regulations for collection, analysis, and publications of information about MAID cases, as they must be reported to the minister by all MAID providers. The MAID law also specified a punishment of jail time for those who would contravene those regulations, destroy or forge documents, and so on. So far, so good. So I would think that reading the law even now, you may get the impression that there is a serious effort to balance the access to medical care for a mature, competent, well-informed persons who are at the end of life, while at the same time protecting the life of all other Canadians. But the problem with the implementation emerged right away. Canadians started to receive MAID within days of the approval of the law, but no regulations were in place to say what should be reported and to whom should be reported right away. And during this void, all provincial governments scrambled to develop their own often rudimentary report forms for MAID providers. And then later government came up with the interim monitoring reports, which they admitted are incomplete. So it took 2 years and 4 months before the federal monitoring regulations were issued, and then another year and a half before the first federal report of MAID was released, which presented the results of this collection of the data. In the meantime, of course, many of us, many people across Canada became especially concerned about the state of affairs. And I will quote from a paper in World Medical Association of a group of Canadian physicians that the failure of adequate oversight, review, and prosecution for non-compliance with these legislations are a serious problem for the program. Now, those of us who hope that the first annual report of the federal government could relieve our concern were very disappointed. The report, which came in July of last year, was set up to explicitly provide a societal perspective. And it did not attempt to systematically analyze whether every MAID cases was reported or not, or whether every case fulfilled the legal obligation as concerned the eligibility criteria and safeguards. The explanation offered was that, well, these are matters of criminal law, and enforcement of the criminal law is the responsibility of the provincial and territorial governments. What these provincial and territorial governments did about this matter, well, only Ontario and Quebec released some information about their examination of MAID reports from their provinces. But there is no information in the public domain in the remaining 11 jurisdictions in Canada. To summarize, it means that of the 13,000 deaths reported in the first federal report last year, we have some evidence that these reports produced by MAID providers were scrutinized in only 3,000 deaths. So our last hope that the accountability and transparency of the MAID program can be addressed was the promise, which was in Bill C-14, that 5 years after implementation of that law, there will be a parliamentary review started. And that then was supposed to start in June 2020. But this legal obligation was ignored. And instead, we have now the draft of Bill C-7. And Dr. Teng, I think, already explained what is the essence of this new legislation. So, one, removal of several safeguards, which were thought to be absolutely crucial in the year 2016. And yet, we're doing at the time, we actually don't know if those safeguards were followed in the past 5 years. And no justification was really provided in Bill C-7 for the particular removal. And the second, the Bill C-7, as you heard, is extending criteria of eligibility outside of the situation where natural death is reasonably foreseeable. Yet, we don't know how often these original criteria has been followed to make these MAID intervention to comply with the criminal law. So, do we have, as court asked, carefully designed system that imposes strict limits that are scrupulously monitored and enforced? I don't think so. I suggest that we have to ask also, given the situation and the failure of monitoring and reporting, is this the right time to move ahead with the overhaul of the whole program as Bill C7 is proposing. So these are my concerns, and I will be very interested in your questions and maybe comments from my other panel members. Thank you.